So, let's kick things off with a big question. Why isn't every court case just a total free-for-all? Well, the answer is that we have a system that's specifically designed for consistency, fairness, and predictability. And that entire system is built on one single powerful idea: precedent. By the end of this, you're going to know exactly how it all works.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, welcome to this new to law breakdown. If you're getting ready for the SQE1, then you know that understanding how judges make and follow the law is, well, it's everything. Today, we are diving deep into a cornerstone of the English legal system, case law, and the doctrine of judicial precedent. We'll start with the why behind it all. Then we'll get into the different types of precedent, the 4 key tools judges have in their toolkit, the actual rules that came from some landmark cases, and then we'll put it all together with a final rapid recap. Let's get into it. First up, why does any of this even matter? This is the bedrock for everything else we're about to cover. So, what are we really talking about? Judicial precedent is this simple but incredibly powerful idea that a court's decision in one case sets a rule that judges in later, similar cases have to follow. This is how we get what's called case law or judge-made law. It's built up over centuries, one decision at a time.
In England and Wales, courts follow a system where the decisions made by higher courts must be followed by the lower courts in future similar cases. That system is called the doctrine of judicial precedent. The idea is simple. The law should be consistent, predictable, and fair. 2 people in 2 different courts shouldn't get 2 completely different outcomes from the same set of facts.
This is a Latin phrase meaning stand by what has been decided, and it is literally the organizing force behind the English common law system. Stare decisis means that once a legal point has already been decided by a higher court, lower courts must follow that same reasoning when they face similar facts. You don't want 2 people with the exact same case getting 2 totally different outcomes depending on which judge they end up with. Stare decisis prevents that. Now, inside that doctrine is where the next 2 terms become crucial: ratio decidendi and obiter dicta. Ratio decidendi means the reason for the decision. This is the legal rule that comes out of the judge's reasoning, the actual binding principle the case creates. This ratio becomes part of case law and must be followed by lower courts in future similar cases. This is the part of the judgment that becomes precedent. Then we have obiter dicta, which translates to other things said. These are statements made by the judge that go beyond the essential reasoning of the case. They might give hypothetical examples. They might mention what the outcome might have been if the facts were different, or they might comment on areas of law outside the immediate issue before them. These remarks do not create binding precedent, but they can still be persuasive. Other judges might still use them in later cases if the reasoning is strong, logical, or influential. So, to connect it all, stare decisis is the rule that says courts follow past decisions. Ratio decidendi is the part of the judgment that must be followed. Obiter dicta is everything else said. Influential, but not binding.
Okay, so if judges have to follow decisions from higher courts, the next obvious question is, who's higher than who? The power of a precedent, you see, is directly tied to which court it came from. And this brings us to the absolutely crucial concept of the court hierarchy.
Let's break down this pecking order, nice and simple. At the very top, the final boss, you have the UK Supreme Court. Its decisions bind every single court below it, no exceptions. Right below them, you've got the very powerful Court of Appeal. It binds all the courts beneath it, and as we'll see in a minute, it generally has to follow its own past decisions too. Then there's the High Court, which binds the lower courts like the Crown Court and County Court. And what about those courts at the bottom? Well, they're on the receiving end. They don't set binding precedents, they just have to follow them.
Okay, so that hierarchy leads us to a really key distinction. Not all precedents are made equal. Some are like direct orders, and others are more like helpful suggestions. So let's break down the difference between a precedent a judge must follow and one they might follow.
Here we go. Side by side. A binding precedent is like a direct command. If you're a high court judge and the Court of Appeal has already ruled on a similar point of law, that's binding. You have no choice. You have to follow it. A persuasive precedent, on the other hand, is more like getting some really good advice. A judge in England might look at a case from, say, the Supreme Court of Canada and think, that's a brilliant way of looking at it. I think I'll use that logic here. They're not forced to, but they can be persuaded. Same goes for obiter dicta. Those are just things a judge says in their judgment that are kind of by the way and not the core reason for the decision. Interesting, but not binding.
Now, what about the Court of Appeal? It's in a pretty unique spot. It's obviously bound by the Supreme Court above it, but does it have to follow its own past decisions? Well, the answer to that comes from this huge landmark case, Young v. Bristol Aeroplane. The court basically said, yes, absolutely, we are bound by our own past decisions. We have to keep the law certain. But then it created three very specific, very narrow exceptions, like if two of its own past decisions completely contradict each other. This case is so important for understanding how precedent works in practice.
And what about the very top court? Can the Supreme Court ever change its mind? Yes, it can. There's something called the Practice Statement from 1966 that gives it the special power to depart from its own previous decisions when it appears right to do so. But this power is used so rarely. Why? Because legal certainty is king. If the highest court in the land was changing its mind all the time, nobody would have a clue what the law actually is.
Right, so we have all this theory, but how does it actually work in a courtroom? When a lawyer brings up a previous case, what can the judge actually do with it? Let's open up the judge's toolkit because they really only have four main options.
Let's make it crystal clear. Overruling is when a higher court in a completely new case looks back at an old decision from a lower court and says, you know what, that legal rule is wrong. It's no longer good law. They've killed off an old legal principle. Reversing, on the other hand, happens in the same case on appeal. So you lose in the high court, you appeal to the Court of Appeal, and they say the first judge got it wrong. They flip the result, and you win. That's reversing. So overrule kills a rule, reverse changes the winner.
Now for the two most common tools in the box. Following is the default setting. The facts of the case in front of the judge are similar enough to the precedent, so they just apply the same rule. Simple. But distinguishing, this is where the real art of lawyering comes in. Your job as a solicitor will often be to convince a judge that a binding precedent that hurts your client shouldn't apply. And you do that by showing that the material facts of your case are importantly different. By highlighting that key difference, the judge has a way to avoid following a precedent that would lead to an unfair result in your case.
Okay, so we've got the principles, the hierarchy, the tools, and the big rules. Now let's step into a judge's shoes for a second and see how this all comes together in practice. So here's the thought process. First, the judge asks, what was the actual legal reason for the decision, the ratio, in that earlier case? Second, where did that case come from? Was it a court above me? Third, based on that, is this precedent a command or just a suggestion? Is it binding or persuasive? Fourth, are the important facts in the case in front of me basically the same? And finally, after all that, the judge picks their tool. They will either follow, distinguish, or if they're in a top court, maybe even think about overruling.
All right, that was a lot of theory. How about we see how it works in practice? Let's run through a couple of quick questions. This is a great way to check if all those concepts have clicked into place.
A high court judge is looking at a binding precedent from the Court of Appeal, but she feels the key facts in her case just don't line up. So what's her move? Is she going to A, overrule the decision, B, reverse the decision, or C, distinguish the case on its facts? And the answer is C. She will distinguish the case. Remember, a high court judge has zero power to overrule the Court of Appeal. Hierarchy is absolute. She can't reverse a decision from a totally different case either, but she can get around that binding precedent by finding that the material facts are different enough. That is distinguishing in action.
Question 2 for you. Pay attention to the details here. This is an appeal in the very same case, and it's gone all the way up to the Supreme Court. The Supreme Court thinks the Court of Appeal got the result wrong. What's the correct legal term for what they're doing?
You got it. The correct answer is reversing. Remember that key distinction we drew? Because the Supreme Court is changing the result for the specific people in the case that is right there in front of them on appeal, they are reversing the lower court's decision. They aren't just striking down some old legal rule from a different case.
Fantastic. Okay, let's wrap this up. We're going to summarize the essential, must-know points, and then I'm going to flag the most common traps that students fall into on this topic in the exam.
Here it is, your final checklist, your cheat sheet for judicial precedent. Stare decisis is the core rule. The hierarchy dictates who has power. Binding is a must, persuasive is a maybe. A judge has four main tools: follow, distinguish, overrule, or reverse. And finally, remember that ECHR decisions advise, they don't command. If you can lock these 5 points down, you are in a really solid position.
And please watch out for these common mistakes. They are easy marks to lose. Number 1, don't mix up overrule and reverse. Number 2, don't say ECHR decisions are binding. Number 3, remember the Court of Appeal is stuck with its own history thanks to Young v. Bristol Aeroplane. And finally, never, ever think a judge in a lower court can just ignore a binding precedent from a higher one because they don't like it. That is a guaranteed way to get a decision overturned.
So now you know how judges follow and shape the law. But it begs a question, doesn't it? Where do these laws come from in the first place? We're going to find out the answer in our next New to Law breakdown. As always, thank you for watching. Good luck with your exam prep, and we appreciate you all. See you next time.